May it please the court. My name is Emma Favela, and along with my co-counsel, Katherine Stephenson, we represent petitioner in today's case of students for fair admission via the University of North Carolina. I'll be answering the following question presented. Is race-conscious affirmative action consistent with the 14th Amendment to the United States Constitution? I'll be addressing the following 2 points in arguing that the affirmative action race-conscious is not consistent with the 14th Amendment in the United States Constitution. My first point being that affirmative action is now being used as a disadvantage due to the fact that the admission committees check race and use it in a factor of acceptance and or may be used as a disadvantage. Along with affirmative action gives the minority population opportunities while taking away the rights and opportunities of the majority population. Moving on to my first point, affirmative action is now being used as a disadvantage due to the fact that the admissions committee checks race and may use it as a factor of acceptance and or may be used as a disadvantage. Race should not be a reason to be accepted or not accepted into a university and or school. As stated in Fisher v. the University of Texas Austin, the respondent argues that to uphold a higher education system, a critical mass should be met to reflect the diverse society and prepare students for a diverse working society. However, in Brown v. the Board of Education, people cannot be excluded because of their race. Although the situation of today and then are flipped, the logic remains the same. These statements prove that affirmative action should not choose which students should have a disadvantage or an upper hand to being accepted because they were born with a certain race. When affirmative action was still trying to be accepted, Senator Wilson argued in debate over a support for newly freed slaves. He argued that support was needed to counter discriminatory laws in the southern states. A Republican senator from Pennsylvania, Mr. Cohen, disputed this allegation. He argued that the United States Constitution provides that the rights of freemen cannot be violated. He pointed out that the Fifth Amendment already contains appeals against discriminatory laws. He concludes that the laws providing special privileges and remedies should not be allowed to newly freed slaves because the Constitution already protects all rights of all American citizens. Just how Senator Cohen argued in 1866 how the newly freed slaves shouldn't have some privileges and remedies due to the fact that they have already got rights in the Constitution and the Fifth Amendment along with that times have changed, which mean the community is more diverse naturally because people are being more accepted now. In 2003, Greta v. Bellinger, Justice O'Connor also mentioned that while diversity on campus is an important aim, this type of affirmative action should have a time limit. She predicted that 25 years after the case, the use of racial preferences will no longer be necessary to further the interests it approved today. Furthermore, why affirmative action should not be used in college applications because the racial preferences of in the 14th Amendment was passed by the Senate on June 8th of 1866 and ratified 2 years later, on July 19th of 1868. The 14th Amendment granted citizenship to all persons born or naturalized in the United States, including formerly enslaved people, and provided all citizens with equal protection under the laws that they have gotten. The rights are now equal to another person. Affirmative action was only originally being used for newly freed slaves, but they are now using affirmative action for all races. Moving on to my second point. Affirmative action gives the minority population opportunities while taking away the rights and opportunities of the majority population. Originally, after the Civil War, people were still trying to find ways to make the newly freed slaves have equal rights. Some people in the Republican Party thought that if they gave the newly freed slaves some rights that the normal population didn't get, it would help them get on track and try to live a normal life. Many believe that the new citizens of the United States, including the newly freed slaves, should still have the same protection and privileges and legal remedies as all other citizens, but nothing more. They thought that special relief laws were unconstitutional and unnecessary. When the Republicans wanted to get affirmative action involved, they had the idea that it would help the minority, but mostly freed slaves have the rights. Unfortunately, years later, people are using affirmative action to sometimes favor minority groups instead of the overall population. In Regents of the University of California B. Baque, the medical school of the University of California had two different admission programs. One was where the candidates must have above a 2.5 GPA or will be rejected, although they had a second admissions choice. At the time, in 1973 and 1974, special admissions programs where applicants had the grade point average of 2.5 GPA. The applicant would have been asked if they would like to be considered an economically and/or educational disadvantage. Applicants and members of the minority group, which included African Americans, Chicanos, and Hispanics, along with Asians and Indians. If an applicant was found to be disadvantaged, then they would have to be evaluated in a very similar method. Although the special applications did not have to meet the requirement to have a GPA above 2.5, they were not compared to other applicants who had to have a GPA higher than 2.5. In the case of the respondent, he applied to Davis and was a white male. He applied in both years of 1973 and 1974. At the time, there was no disadvantaged white students who were admitted in the special program, although they had many to apply, but nobody was admitted or was allowed in. Even though in 1973 the respondent scored a 468 out of 500 the first time he applied, he was still rejected due to the fact that the school was only taking students that scored above 470, along with the fact that there were still 4 special admissions programs slots still open, but since he had turned in the application late in the year, he was rejected. However, in 1974, the respondent applied once again, except this time he applied early in the year. Nonetheless, the applicant was still rejected despite having an overall score of 549 out of 600. In both years, the applicant was not put on a waiting list, even though the special applicants with significantly lower scores were accepted immediately. Following his second rejection, the respondent filed this action in state court for mandatory injunctive and the declaratory relief to compel his admission to Davis. He was stating that the special admission program was disqualifying him because of his race. This meant that violating the Special Protection Clause of the 14th Amendment along with provision of the California Constitution. The respondent filed this lawsuit in state court to enforce that he shall not be disqualified from practicing in any federally subsidized program because of the race or color under the section of 601 of Title V1 of the Civil Rights Act of 1964 states that no person shall on the ground of race or color be excluded from practicing in any program receiving federal financial assistance. The California Supreme Court ruled that the special admissions program is clearly the overriding state interest of consolidating medical professionals and increasing the number of physicians while trying to treat minority patients without providing any state constitutional or federal reason. The court found that the petitioner's special admission program violated the Equal Protection Clause because the petitioner failed to discharge his responsibility to show that the defendant would not have been accepted without a special program. This shows that in the special applications of 1973 and 1974, they favored the minority groups and instead of the overall students. They took opportunities away from the students due to their race. In conclusion, affirmative action is not consistent with the 14th Amendment of the United States Constitution. The reason being that the admission committees look into race and use it as a disadvantage or upper hand depending on the student's race, along with affirmative action gives the minority groups an upper hand in making it into universities instead of giving the whole student body opportunities. Affirmative action was originally used to help the newly freed slaves to have opportunities to live an equal life and equal rights. Although it was created in 1964, the modern world uses affirmative action as a disadvantage and takes opportunities away from students. I will now be passing it on to my co-counsel, Katherine Stephenson.
May it please the Court, my name is Katherine Stephenson, and I too will be representing the petitioner, students of fair admissions, in today's case. There's one question presented. Is race-conscious affirmative action consistent with the 14th Amendment? I'll be using the following 2 points in arguing that race-conscious affirmative action is not consistent with the 14th Amendment in the United States Constitution. Number 1, affirmative action no longer fits in with the norms of society. And number 2, affirmative action has nothing to do with equality and is barely based on equity, which causes it to be unconstitutional. Moving to my first point. Affirmative action is a really common thing that can be found anywhere and everywhere at some point or time. In America, affirmative action was technically first created after the Civil War to help with desegregation, and it most definitely did that. But that was back then when we needed help because nobody wanted to do anything, especially the South. Now, affirmative action has tried to help create such a level playing field that it has become unfair without realizing it. In reality, affirmative action no longer fits into the norms of society because of how advanced we have become, and we no longer need affirmative action in America. Without a doubt, there's a lot of history behind affirmative action, but every time it was brought back, it slowly but surely disappeared because it would no longer fit in with the norms of society. One example would be the Freedmen's Bureau. The Freedmen's Bureau was created during the American Reconstruction era to mainly help former slaves, but ended up helping some poor white men jump back into society. It was the affirmative action of the Reconstruction era. Slowly but surely, former slaves and poor white men slithered their way into society and were able to fend for themselves. Once that started to happen, the government started to back off on it, and then sharecropping became an issue. But sharecropping wasn't considered discrimination, so the Freedmen's Bureau went away, and the government turned away from it and began to work on other things. Another example could be when President Truman decided to step in and stop the racial discrimination that was happening in the military. What was happening was that the African American active duty members were forced to be at the bottom of the military pyramid. They had to cook, clean, and deal with very dangerous bombs, rather than fighting for their country like they signed up for. Also, fun fact, at the time this was happening, the military was the number one African American employer. There must have been a lot of people who were just stuck and couldn't move up in the rankings just because they were African American. So when President Truman saw this, he decided to take action into his own hands. He created the executive order label 9981 and personally made sure that the desegregation was happening. But once it started to happen, and it became consistent, President Truman and the rest of the present and future government moved away from that topic and never really looked back, which slowly caused affirmative action to go away since they were all being treated equally. A third example would be when President John F. Kennedy created the Executive Order 10925, which banned all racial discrimination in the employment process. Just like the other examples, President Kennedy noticed that people weren't getting jobs just because of their skin color and decided he was going to step in. His executive order promised equal treatment and chances for everyone during the hiring process. But unlike the other two examples, when his executive order started doing its magic and creating an equal playing field for everyone, he died and wasn't able to continue helping. After President Kennedy was assassinated, the government tried to continue to help with desegregation in the workforce, and one of those ways they tried to help is the last example of affirmative action returning and disappearing in this part of the argument. One last example would be when President Lyndon B. Johnson created the Executive Order 11246, which completely prohibited all discrimination in the workforce, no matter what section it was talking about, whether it was the hiring process or the firing process. The only big difference between President Kennedy's executive order and President Johnson's executive order was that President Johnson's executive order included everything and everyone in the workplace, including women and minorities, which had never happened before. But once again, as big as it came, it slowly left, and the government quit focusing on it, causing affirmative action to leave. In total, all of these examples came and slowly left, and the affirmative action came and left with it. And that is exactly what is happening now with this case. Affirmative action came when it was needed to be there, and now it is leaving because everything Affirmative action came when it needed to be there, and now it is leaving because everything is becoming unfair to everyone. In the case Greta versus Bollinger, the Supreme Court justice made the ruling that affirmative action would be officially gone in the next 6 years, so by 2028. So just like in the example said before, affirmative action will come and go, but this time it has seemed that it is left before the deadline came. So in the end, in the court case Greta versus Bollinger would need to be overruled because of the affirmative action that it has brung has already left years before the deadline, basically meaning that affirmative action no longer fits in with the norms of society. Moving on to my second point. Affirmative action has nothing to do with equality and is barely based on equity, which causes it to be unconstitutional. The 14th Amendment was created just after the American Civil War with the 13th and 15th Amendments. The 14th Amendment was and is still a big deal because it makes sure everyone gets equal rights, opportunities, and good treatments from others. So in other words, the 14th Amendment was created to the 14th Amendment was made to create and keep equality amongst the people of America. This goes without saying that violating the 14th Amendment is a big deal, and sadly that is what affirmative action is doing. While affirmative action has helped a lot of people, it has also created discrimination and biased opinions in the workplace and schools over race. America runs on the rob Peter to pay Paul plan, which is when you have to take something away from someone, which leaves them at a disadvantage, in order to give that thing you just took to someone else. To put it into context, it means all the opportunities given to the minority races of America were taken away from the majority races of America and were never given back, which is extremely unfair and does not create equality at all. One instance of affirmative action being unfair is in the court case University of California versus Bakke. In the University of California versus Bakke court case, the big story was that the University of California was setting aside 16 places out of 100 available places for the minority races of America. When they went to court for their quota, the Supreme Court ruled that their quota is unconstitutional, and that is entirely true. To set aside seats for the minority population just because they are a part of the minority population is a violation of the 14th Amendment. Because the 14th Amendment talks about equality, helping the minority population achieve their goals without helping the majority population is unfair and unconstitutional. And that is exactly what the University of California was doing before they had to go to court for it. Affirmative action also isn't fair because not one person is getting the same thing as the other. In the universities, one person might be getting a free master's degree just because they are part of the minority races of America, while the other person is drowning in student debt trying to get an associate's degree with no help because they are classified as a privileged race of America. This hypothetical example is so far away from the idea of equality that you wouldn't even be able to see it if you went back 10 steps. So affirmative action does not create as much equality as most people would think. Instead, it drives us further away from equality and more into discrimination and racism. When looking at affirmative action and what it does, people realize that affirmative action is very similar to the idea of equity. Equity in education is defined as making sure that the equal opportunities given to everyone are adjusted to make room for students who might need extra help and attention. While equity does great things, it becomes unfair to people when using the idea of equity. It becomes unfair to the people when using the idea of equity because everyone can get a different outcome in the workplace and schools. Creating equity in schools and the workplace is extremely hard since not everyone has the same ideas and goals to complete in their lives. Affirmative action, rather than making sure everyone is on the same level, helps people so that in the end no one has the same outcome and neither equity nor equality is present. Affirmative action allows students that don't have as many opportunities to get extra help and to succeed and surpass the minority races of America just because they are part of the minority races of America, which is very immoral. So really, in the end, As much as affirmative action has helped people in the past, it is still inconsistent with the 14th Amendment because affirmative action doesn't have anything to do with equality, which is what the 14th Amendment is about, and because affirmative action is similar to equity but does not give everyone the same outcome, so it is considered unfair. We will now be taking questions.
Thank you, Counsel. Does the Equal Protection Clause of the 14th Amendment prohibit race-conscious affirmative action?
The Equal Protection Clause of the 14th Amendment does prohibit race-conscious affirmative action because affirmative action does not advocate for equality. Rather, it continues a cycle of inequality and reverse racial discrimination, and therefore is prohibited under the 14th Amendment.
How does legislation enacted by Congress in the 1860s and 1870s affect your answer to question 1?
In the Act of 1866, it prohibited discrimination and was considered constitutional by the Committee of the Framers, and this act was the complete opposite of what affirmative action is. It is the complete opposite of what affirmative action is, meaning that the Act of 1866 was constitutional and affirmative action can't be. The Act of 1875 further proves that affirmative action is unconstitutional because this act was just a follow-up for the Act of 1866 and made sure everyone was guaranteed freedoms.
Let's assume that the framers of the 14th Amendment concluded that race-conscious legislation was constitutional in the 1860s and 1870s. Would that argument still work more than 150 years later in a very different society?
No, the argument would not work because affirmative action was originally created to help former slaves catch up with society. Back when we needed affirmative action to create an equal platform for everyone, where everyone would get the same rights and opportunities and would have to work with themselves to get where they want to get.
Let's assume that the framers of the 14th Amendment thought that people of African descent deserved certain race-conscious privileges due to the unique context of slavery. Would the framers have argued that members of other races such as Hispanics, Asians, and Native Americans could receive similar privileges?
The framers of the 14th Amendment would have probably thought that the other races of America would have deserved affirmative action because of how they were discriminated against in this country.
What would the framers of the 14th Amendment have thought about affirmative action policies that benefit people on the basis of sexual orientation or gender identity?
The framers of the 14th Amendment would not have thought about whether affirmative action would affect people on the basis of sexual orientation or gender identity, because affirmative action mainly revolves around the race of someone, and because back then the LGBTQ community were heavily discriminated against, and sadly they still are. And even though it is written in the Constitution that we can't discriminate someone because of what they identify as, people still do.
Does Brown v. Board of Education prohibit race-conscious affirmative action? In your answer, please address Bake and Grutter.
Yes, Your Honor. Brown v. the Board of Education prohibited race-conscious affirmative action. The main purpose of Brown v. the Board of Education stopped segregated schools and segregation in total, and made students go to the same school in the same area without caring about their race or ethnicity. Although in Grutter v. Bollinger, Justice O'Connor did state that diverse student body is important and has educational benefits, and this type of affirmative action program should have a time limit. Instead, that 25 years after the case, the use of racial preferences will no longer be used.
In 2003, Grutter observed that 25 years after this case, the use of racial preferences will no longer be necessary to further the interest approved today. Will there ever be a point in time in which racial preferences are no longer needed? If not, should the court allow racial preferences to go on?
Yes, Your Honor. Racial preferences should not be used anymore because now college admissions check race. In Bakke v. the University of California, they were using race in college admissions. and if the race did not qualify in a specific qualification, they would be rejected. They use racial preference to make a more diverse student body, but rejecting a person or applicant due to race is not a good reason, and it goes against the Equal Protection Clause.
Should Grutter v. Bollinger be overruled? Please address the Supreme Court's recent discussions of stare decisis in Dobbs v. Jackson Women's Health Organization.
Yes, Your Honor, Grutter v. Bollinger should be overruled because race should not be considered during a college application and shouldn't be the reason why applicants are denied or being held back from achieving their goals. It goes against the Confrontation Clause and along with the 14th Amendment.
If the court declines to overrule Grutter, can the plaintiffs prevail?
If Grutter v. Bollinger gets overruled, then the plaintiffs would win because the plaintiff wants Grutter v. Bollinger to get overruled so that affirmative action would go away. But if Grutter v. Bollinger does not get overruled, the plaintiff would still win because in that case, Justice O'Connor set a time limit for affirmative action to no longer be needed by 2028, and affirmative action would no longer be applied or acceptable.
If the court overrules Grutter, will the military have difficulty recruiting a diverse armed service?
No, military would not have difficulty recruiting a diverse armed service because the purpose is presented by the military has different compelling interests that the purpose is presented by the schools. The purpose of the military is to protect the country, and that does not correlate with the diversity, while the purpose of schools and university is to educate schools.
Thank you, counsel.
If there are no further questions, it is for these reasons that we pray that the court overrules the lower court and rule in favor of the petitioner. Thank you.